Hi, everyone. I'd like to introduce myself. My name is Laura Schultz. I am the Executive Director of Research here at the Rockefeller Institute, and I'm very excited to introduce today's program. The Center for Law and Policy Solutions is one of our most important initiatives here at the Rockefeller Institute. The center was designed to investigate how decisions of law and policy affect ordinary people in communities in order to help policymakers, community organizers, and the public develop practical solutions to public policy issues. The center, which was established in 2017, has the principle that better policy starts with better data. The researchers affiliated with the center understand the need to integrate diverse perspectives. Effective policies that have impacts on the day-to-day life of our communities cannot be developed in a vacuum by attorneys and economists alone. The center is a collaboration among several institutions with a wide variety of expertise, including the Rockefeller Institute of Government, SUNY Empire State College, Hudson Valley Community College, the Government Law Center at Albany Law School, the Rockefeller College of Public Affairs and Policy at the University at Albany, and the University at Buffalo School of Law. People at all of these faculty, administrators, fellows, and students at all of these institutions come together to study important, pressing public policy issues. The flagship initiative of the center is the CLPS internship, which are here to learn from and celebrate today. Through these internships, students at the University at Albany, Empire State College, and Hudson Valley Community College learn about the politics of law and policymaking. It helps them understand how effective government can impact people's lives. In addition to creating just a learning experience about how policy is developed, our goal is to provide an opportunity for professional development. This is often the first opportunity students have to learn about working in a professional policy environment. This is our 6th cohort of students this semester, and I want to commend them for embracing this opportunity in such a unique time. Most of our other cohorts have come together in our office in the carriage house in the back and worked together for several hours a week. This group has worked entirely virtually through Slack and Zoom, just like the rest of us have. They've built an impressive dynamic and learned what it means to be a professional in this environment. They have been led by Dr. Laura Rabineau, who is the Deputy Director of Research here at the Rockefeller Institute of Government. Laura has a unique perspective to share with them. She's worked in the New York State Legislature, developed foreign policy research, and is leading the Rockefeller Institute's policy portfolio related to environmental policy issues. Her prior work has moved between public policy, research, and practice. And with that, I'd like to hand this over to Laura so that she can introduce this year's cohort.
Great. Thank you so much to our Director of Research, Laura Schultz, and thank you to everyone for joining us here today. As noted, my name is Laura Rabineau. I'm the Deputy Director of Research at the Rockefeller Institute and the Director of the Internship Program at the Center for Law and Policy Solutions. I have the honor of introducing today's presenters, who are all a part of the Center for Law and Policy Solutions internship program this semester. As Laura Schultz noted, the program works with undergraduate students at University at Albany, Empire State College, and Hudson Valley Community College over the course of a semester, lending hands-on and, especially this year, virtual exposure to policymaking, advocacy, and research. This semester's cohort, who you'll hear from in just a moment, bring a wealth of experience and a diversity of disciplinary backgrounds to bear. They include, from the University at Albany, Genevieve Bombard, Catherine Reed, and Amari Roque, and from Empire State College, Joshua Kapczynski, Sammy Matlin, and Hoshi Salcido. I'd also like to recognize our incredible graduate assistant, Erin Vallely, from Empire State College. Over the course of the last semester, They have all been researching environmental and environmental justice policy. And in particular, their collective research project has focused on state green amendments, the findings of which they'll present here today. Following the presentation, we'll have some time for Q&A from attendees. So you can submit your questions into the Q&A function on the Zoom taskbar at the bottom of your screen. Without any further ado, however, I want to welcome the entire cohort to begin their presentation. Welcome.
Good morning, everyone. Thank you for joining us today. This presentation will share our research into the potential impacts of state-level green amendments. Environmental policy addresses issues in regard to water and air pollution, land conservation, and wildlife protection. For decades, our Earth has undergone a plethora of environmental problems such as global warming, pollution, and deforestation. While federal environmental policies such as the Clean Air Act and the Clean Water Act have contributed to improved environmental conditions, they have not been as impactful as environmental advocates believe they need to be. For this reason, environmental advocates have been lobbying for more environmental policies to address persistent problems. Green amendments are an example of this type of policy. These state-level constitutional amendments protect a person's right to clean air, clean water, and a healthy environment. So far, Pennsylvania and Montana have passed and implemented green amendments in their states. New York, along with 9 other states, are currently considering adding green amendments to their constitutions. Being that the Green Amendment will be voted on in November of 2021 in New York, this research was conducted to assess the potential impacts of passing the New York State Green Amendment by looking at the outcomes of the amendments in Pennsylvania and Montana. This research will not only offer nonpartisan insight into potential impacts of the bill, but will also be useful for other states as they consider adopting their own green amendments to their respective constitutions. Montana and Pennsylvania already enacted green amendments. In New York, it's under referendum, and 9 other states have proposed legislation.
Since New York residents will be voting on the Green Amendment referendum in November, we were interested to know what the potential impacts of the constitutional amendment might be, and thought that this information would be useful for voters in the fall. To gain insights to the potential impacts in New York, we chose to do a comparative case study of Pennsylvania and Montana's Green Amendments. We wanted to understand how stakeholders in each state framed the Green Amendment, what the language of each bill was, and what the outcomes were after passage. Collected information about the amendment's framing in each state and used discourse analysis and comparative analysis methods to understand the potential impacts and outcomes of New York's amendment if it passes in November. We wanted to know about arguments from different perspectives to see if the reasoning matched the outcomes after the amendment's passage. We were also interested in how the language of the amendments impacted the strength and effectiveness of the amendment. We used the information about Montana and Pennsylvania's Green Amendments to speculate about the potential outcomes and impacts of New York's proposed amendment. We compared the discourses around each amendment and analyzed the outcomes of each state to give us an idea of the potential outcomes we could see with the New York Green Amendment. We also hope that this research can help other states to understand the potential impacts of these amendments as they consider their own green amendments.
The Pennsylvania Green Amendment, or the Pennsylvania Environmental Rights Amendment, Article 1, Section 27 of the Pennsylvania Constitution, was passed in 1971 by the Pennsylvania legislature and the voters of Pennsylvania. Legislators unanimously voted for the bill in the consecutive 1969, 1970, and the 1970-1971 legislative sessions. It passed with approximately 79% of the vote of Pennsylvania residents. Pennsylvania, which refers to themselves as a Commonwealth and not a state, specifies the reach of their amendment more than New York does in their proposed Green Amendment. Pennsylvania codifies not only the right to clean air and pure water, but the preservation of the natural, scenic, historic, and aesthetic values of the environment. Therefore, if the Commonwealth strictly follows the amendment, it has to take into consideration how their actions will impact the appearance of the environment and the historic sites throughout the state, and not just how their actions will contribute to pollution. Additionally, the Pennsylvania Amendment makes the Commonwealth the trustee of the resources to conserve and maintain them for the benefit of all the people. This means that the Commonwealth and its agencies are the ones who have the responsibility to conserve the environment. The legislature, which passed the bill unanimously, often talked about the impact it would have on future generations. The amendment states that Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. And supporters often stress how the environment could impact their descendants. In tandem with this idea, supporters often expressing such a bill is for the people. They discuss the negative impacts pollution can and will have on mankind. Therefore, he said the bill should be passed with urgency. Additionally, they frequently discuss the trusteeship of the bill. The sponsor of the bill also highlighted how the amendment would shift the burden of proof. He stated that those who would potentially create the pollution have to prove their projects will not pollute. Those subject to the pollution would not have to sue first. Overall, the courts of Pennsylvania decided the impacts of the amendment. The Pennsylvania Supreme Court dampened the reach of the Environmental Rights Amendment with the 1976 case Payne v. Casale. A public project, which would take up some of the land of a public park, was challenged. To decide whether the project violated the Environmental Rights Amendment, the court created a three-part test, which asked whether 1, the project followed current environmental statutes and regulations, 2, they showed an effort to reduce environmental damage, and 3, the environmental harm outweighed the benefits of the project. This three-part test was not officially overturned until 2017. In that time, only 1 out of 24 challenges resulted in any Pennsylvania court finding a violation of the amendment. The 2013 case, Robinson Township et al. V. Commonwealth, found certain parts of a drilling project to be in violation of the Environmental Rights Amendment. The court stated that the government has the responsibility of anticipatory protection of the environment. This means they have to consider pollution first, not go ahead with a project and attempt to fix environmental damages later. However, this was a plurality opinion, meaning the opinion was non-binding in future decisions. In 2017, through the Pennsylvania Environmental Defense Foundation v. Commonwealth decision, the three-part test was finally overturned, moving toward a revival of the Environmental Rights Amendment. The Pennsylvania Environmental Defense Foundation sued the Commonwealth for selling leases of state land for the extraction of natural gas and using the revenue in the general fund of the Commonwealth. The Pennsylvania Environmental Defense Foundation argued that the use of funds took away resources from the Department of Conservation and Natural Resources, reducing their ability to protect the environment and therefore to uphold the Environmental Rights Amendment. They also argued that allowing the leased land to be used for natural gas extraction was in violation of the Commonwealth's duty to preserve and maintain the natural resources of the Commonwealth. The court held that the amendment is self-executing, meaning the government of Pennsylvania does not have to pass any additional supporting laws for it to be enforced. In this case, the court also broadly interpreted the public trust language, finding that the Commonwealth can use the trust assets for conservation only and must maintain the resources as the trustee. The full text of the amendment was finally reinstated.
Like Pennsylvania, Montana also has a Green Amendment. In 1972, 1 year after Pennsylvania's Green Amendment passed, the citizens of the state of Montana adopted their version of a Green Amendment to their constitution during the 1972 Constitutional Convention. From early on in the convention process, environmental protection was voiced as a high priority. The Constitutional Convention, composed of citizen delegates, was charged with breaking from the state's past environmental policies, which had been heavily dictated by wealthy mining companies. Delegates recall that the environmental provisions were the most heavily debated of the convention. While the delegates largely agreed with the need for a Green Amendment, debates within the topic included whether to employ the vague descriptives of clean and healthful, how the rights would be enforced, and questions of how to balance the state and federal powers. Compared to Pennsylvania, Montana's Green Amendment is less grounded in public trust doctrine. Some delegates perceived the concept as an intrusion on private property rights. Concerning enforcement, Representative Dahoud, who chaired the Declaration of Rights Committee, advised the delegates that constitutional provisions are presumed to be self-executing, particularly within the Bill of Rights. And as such, they could be enforced on their own by the courts, without requiring an accompanying direction from the legislature. On June 6, 1972, Montana delegates ratified their draft constitution, which included environmental provisions both among the Declaration rights of Article 2 and among the environment and natural resources of Article 9. While Montana's constitution represented a vast expansion of personal rights, it is sometimes unclear where the authority of state ends and where individual rights begin. It declares that environmental maintenance is a shared responsibility between the state and its residents. One of the inaugural cases following the amendment's passage is Douglas v. Judge in 1977. In this case, the plaintiff questioned if state loan and bond financing on renewable resources served a public purpose. The court ultimately ruled against the plaintiff, citing the amendment to justify state actions protecting or improving the environment. The most significant test from Montana's new expression of state constitutionalism came in the case of Cadillac v. Anaconda in 1979. At issue was the development of a mining waste dump in a residential neighborhood. The Anaconda Mining Company intended to avoid performing an environmental impact statement by exploiting a loophole in the state's statutory language. The court denied the plaintiff's claims and set a precedent whereby the court would show deference to federal standards rather than to the more proactive state constitution. Montana's Green Amendment was revived in another case, the Montana Environmental Information Center, or MEIC, versus the Department of Environmental Quality in 1998, or the DEQ. This case involved mining wastewater, which could potentially contaminate a public river. Two issues arose from this case. The first involved the question of standing. Could an environmental advocacy group such as the MEIC claim standing or the right to bring a lawsuit in a case of contamination of public waters? And the second question asked, could the court determine the point to which a statute passed by the legislature was arbitrary or unpredictable? In this case, the court decided for the environmental advocates, and it set new precedents in forms of judicial scrutiny, standing, and precautionary principle. Several cases have now followed in the MEIC's wake, including a private property lawsuit in Cape France Enterprises versus the estate of Pede in 2001, and a case which could potentially expand the public trust doctrine to include atmospheric pollution in Held v. Montana from 2020.
The New York Green Amendment was introduced by Senator Jackson on April 30th, 2019. If passed by voters, the bill will add an amendment to the New York Constitution granting residents the right to clean air, water, and a healthful environment. The bill had to be passed through both the Senate and Assembly during 2 separate session years. It is a referendum for a right, meaning that this upcoming November, it will be voted on by the citizens of New York. In New York, proponents of the amendment frame it as a means to advance environmental justice. A statement that encapsulates the supporters of the amendment comes from Senator May, in which she says, "For too long, we have treated these as privileges. And because they've been treated as privileges, they have been denied to some of the least powerful among us." Similarly, Pennsylvania's Green Amendment language explicitly states that the common property in reference to the environment and public resources belong to all people and are therefore not considered a privilege. Additionally, Pennsylvania's amendment names the state as a trustee, which makes explicit that the burden of proof lies with the state, while New York does not have such language. New York focuses primarily on the health of residents, while the Pennsylvania amendment specifies the aesthetics of the environment as a means to preserve natural beauty. Opposition for the amendment centralizes concerns about costs and litigation. This thinking can be summed up into one series of remarks that was made at a Senate session in 2021. In this session, Senator Borrello opposed this amendment to New York's Constitution. Borrello, capturing the arguments of many, labeled the bill as an aspirational goal and stated, "My opposition to this bill today is merely on the unintended consequences this bill may have, including opening up a Pandora's box of litigation. Fears of excess litigation are a common theme among opponents of the bill. However, Pennsylvania, the oldest state to have a Green Amendment, has not had a significant increase in litigation related to its Green Amendment."
Conclusions. Pennsylvania and Montana have shown the importance for states to establish a constitutional backstop in order to prevent potential environmental crises. To date, a majority of the resulting litigation has been directed toward state environmental agencies and not toward private business. The courts have found that state agencies generally have broad discretion to define regulatory standards. The Green Amendments have had their greatest impact in cases where state agencies failed to perform a process of fully informed and considered decision-making. Opponents of New York's Green Amendment have raised concerns about the potential for negative impacts on the business community and local governments, as well as concerns about costs, litigiousness, and judicial overreach. Our research indicates that these concerns are largely unfounded in the available data from Pennsylvania and Montana. State Green Amendments represent what is often termed a positive right. This category of rights has a long history in state constitutions. Concerning judicial enforcement of positive rights, legal expert Jeffrey Usman has said, "A court that exercises restraint is simply performing its traditional and vital role of serving as a check upon the political branches." Overall, the New York Green Amendment might not be as detrimental to business interests as opponents have suggested, nor as expansive as supporters had hoped. However, recent shifts in legal practice may point to increased usage of Green Amendments in the future. Since the turn of the millennium, legal action has become an increasingly popular method for activists to confront climate change. And in this trend accelerated further during the Trump administration. At the same time, the state high courts have shown increasing deference to state constitutions. Nearly 2 decades ago, Barton Thompson Jr., a leading environmental law scholar, assessed that constitutionalizing particular environmental policies seemed premature. But alternatively, he outlined a list of special circumstances where normative law might find these amendments necessary. His list cited environmental issues that involve future generations, such as the depletion of exhaustible resources, the endangerment of species, global climate change, and the use of long-lived toxics. Following many high-profile water crises in recent years, this list appears more prescient. Future research should explore potential interactions between the New York Green Amendment and the state's specific environmental interests and agency practices. This concludes our presentation. We will now turn it back to Dr. Rabineau to moderate the question and answer portion of our presentation.
Thank you all for that informative presentation. Just as a reminder for all of our attendees, you can submit your questions into the Q&A function on the Zoom taskbar at the bottom of your screen. We'll get going with our first question. And it says, you've looked at Montana and Pennsylvania with respect to understanding the potential impacts here in New York. because they're the only states with green amendments thus far. What limitations or qualifications, if any, would you place on your findings, given that these are 3 states we might not typically compare?
Well, yes, thank you for your question. So as we know that Pennsylvania and Montana definitely have some demographic differences than New York. Montana is more rural, has less urban areas, and their situations with the environment and pollution are going to be different from New York State. Pennsylvania, as we know, kind of with their amendment, has an emphasis on the aesthetics of the state and natural land and beauty, but they also have some metropolitan regions. New York, in and of itself, right, has many metropolitan regions, has a lot of rural areas, and is very much focused on the health of citizens and residents of the state. So what we can understand from our research is what could happen at the administrative level within the legal system and how that impacts the individual lives of everyday residents of the state. But until more states pass the Green Amendment, we won't quite know how it will play out, especially because so much of this is focused on the burden of proof being on the state, which means how state agencies are going to react and respond, and also what happens in the courts. And as we know, case law might take decades after a law is passed to become established.
Great, thank you, Sammy. Our second question is, as we move closer to the vote in November, given the rhetoric that you all have discussed in Montana and Pennsylvania and thus far in New York, how would you expect proponents and opponents to frame the vote for residents of New York State?
Based on our research, we would expect that proponents of the bill would frame the Green Amendment in a way that's enhancing environmental rights to New York residents. I think that would be the biggest point for the proponents. Opponents of the bill are more concerned about the vagueness of the bill, costs in litigation. There are several different arguments on all different sides about whether or not costs will be an issue, either beforehand or in the future. And there is vagueness around if litigation compared to the other states will be as severe as an issue as opponents suggest. But I would definitely think that opponents and proponents would focus on cost litigation and their environmental rights.
Great, thank you, Evie. Our third question: what are the potential implications of a state green amendment with respect to enforcing or enhancing environmental justice protections in New York? And then I'll add, there's another related question that's come in related to private actors and whether or not this would also apply to private actors, given the case law that we've seen.
So I'll jump in with the first half of that question. Someone else can pick up the second half relevant to case law. But in the first half, Senator Jackson, who introduced the bill, framed it as a way for state agencies to be more reactive and responsive. So hopefully, if we pass the Green Amendment in November, if we all vote, state agencies, based on his framing, will be able to take more action before things happen.
In regard to the case law, while the amendments do make the states the protectors of the environment, we have seen a number of cases in which environmental rights groups have sued private actors who are contributing to pollution. So if that is any indicator of what will happen in New York State, it would be possible for private actors to be held accountable as well as the state and the public actors.
Great, thank you both. The next question pertains to the public vote. As New Yorkers prepare to vote this fall on the referendum in New York, The vote in Pennsylvania was noted, but the public vote in Montana was not. Could somebody speak to the public vote in Montana and the degree to which that mirrored what happened in Pennsylvania?
I can take this. I would like to give a little context on it. I really enjoyed reading about Montana's experience with their constitutional convention. It was a dramatic story, as Montana had changed so much since its 1889 convention. The vote for the delegates to the Constitutional Convention, they ratified the draft by 100%. When it went to voters, it ended up being, by the slimmest of margins, 50.55% approved of it. So the opponents were not sure, were threatening to contest it. And the governor in the state Supreme Court ended up siding with the 1972 Constitution by 3-2. After this, it has remained popular. There haven't been many amendments to the Constitution, especially compared to other constitutions. In 2010, the Montana voters were allowed to again say if they wanted to do another constitutional convention. 59% said, let's keep that one. It's working really well. Another point is that the delegates that wrote the Constitution have they've been cited as some of the most influential members in Montana in the last 100 years, right after a famous senator of theirs. And they become something of heroes to the state. So it was very interesting to read about.
Great, thank you, Josh. And can you just clarify, when the public voted, because it was a constitutional convention, was this voted on alone or in conjunction with other amendments?
Absolutely, there were several individual items that were voted on, but it was voted on as a package, as the whole Constitution. So the Green Amendment was a point of interest, very much going into the Constitution and during the process where voters were considering it, but it was a package.
Great, thank you so much for clarifying. The next question is about culture. It's asking, given the changing culture of people in the US tends to be individually focused with less of an emphasis on community responsibility, what can we do, and particularly this person's asking about higher education institutions, to help shift the culture towards one that is more based on community responsibility as kind of reflected in these Green Amendments?
So I do want to say that based on our research and looking into things, I don't know how responsible a community can be when, toxic waste dumps are sited in their neighborhoods. And we know that the siting of waste dumps is very much connected to environmental racism, which is a systemic issue. So I think that within the context of higher education, when we think of community responsibility, what we're talking about is community advocacy, because the burden of proof does and should lie within the state to rectify incidences of systemic racism, such as the siting of toxic resources.
In an educational aspect, I think it's very important to frame this as a right. So, our youth and moving forward future generations understand that this is a basic right and that we do have the power to speak up for things we like, we don't like, and the changes we need to see.
Great, thank you all so much. See another question. Given that we're talking about this at the state level right now, they're asking about a federal constitutional amendment. Do you think, given what we've seen thus far at the state level, that we could get to the 2/3 of states needed for the ratification of a federal constitutional amendment?
I would say this was proposed previously by our assemblyman, State Assemblyman Brodsky, to other legislatures that they could encourage this. So it's been an idea, but that's been out there for a long time. I think that was 20 years ago. But state constitutions, they are different. They are more likely, they have positive rights, as opposed to the federal constitution. It's more just negative rights, saying that we cannot prohibit. So it would be a big change. I think that there is interest. The question you're asked, could we get 2/3? This is how I think that there is interest, and it could build across states. Like Hoshi said in the introduction, there are a lot of states that are considering this, and we could see a wave of it across the country, like laboratories of democracy have worked in the past.
Great, thank you so much. And I'm seeing one more question about our forever wild clause in the New York State Constitution and the protection of lands, as with the Adirondack Park. Do you think that the New York State Green Amendment will help enhance perhaps the protection of those already protected lands enshrined in our Constitution and state laws?
I think if we are interpreting it as other states have done and putting the burden of proof with the state, then yes, I think those could very easily work in conjunction. As we saw in other states, it might depend on how the court interprets that and if we actually can move forward with protecting those lands. But if the state has the burden of proof, I think it would be a bit easier to say that not only are they violating the forever wild clause, but now they're also violating this new Green Amendment, which specifies that we need a healthful environment for all people of the state.
I also agree with Catherine when she says that this would emphasize the clause in our state constitution already, because I believe that since with the Green Amendment, people would be able to bring up their rights individually and almost sue on behalf of those lands. I think it would give people who already are in positions of caring about these forests, it would bring more pressure to actually act on the rules that we already have in place.
Sorry, I just like to add a little piece there, but just to expand, I mean, what we've seen in other states, specifically in the ongoing case I mentioned earlier, Held v. Montana, they're actually taking a piece of the Constitution of the tagline of "for future generations," and they're actually expanding on that. So you could really just take anything and not anything, but you could expand. You can expand it through litigation.
I think something to add on to everyone else that is missing from New York's legislation that might make it a little bit more difficult is that we don't have the trusteeship that Pennsylvania has, and we don't have specifically verbiage to say that the burden of proof lies with New York State. So that might be a little bit even more open to interpretation. But again, if the courts uphold that that's what it means, then yes, then it would work very well to protect public lands and forests.
Great, thank you all so much for those answers. I see we've run to the end of our questions, but I want to give you all a chance, especially for those who didn't just get to comment If there's anything final that you'd like to say about your conclusions and about your research through this process.
I would say that one of our main takeaways from Montana and Pennsylvania was that there isn't a severe increase in legislation, but it also does say up to the courts on how this will be interpreted. So it really is up to them if they are going to support protecting the environment with this legislation or not.
And I would say that we really hope that this was a good opportunity to educate New York residents on the Green Amendment and hopefully educate them enough to be able to vote on the referendum in November.
Great, thank you all so much. I want to thank all of our attendees. Of course, all of our CLPS interns here, you all have done a wonderful job, and all of the staff who have supported their efforts and presentation today. I hope that you all have a lovely day, and we will certainly come back to this as the report is issued this summer and as we move towards the vote this fall. Thank you all again. Take care.